We're not even talking about a 0.06. We're not talking about a 0.08, barely the legal limit. You sitting up here telling me it's a 1 in front of his number, and he got on my record under oath and said all I had to drink was a beer. That's insulting to the court. All right, now I'm back to Hunt, back on the record with case number 234463801. All right, Mr. Moore, your appearance, please.
Good morning, Your Honor. Gregory L. Moore, P3 4437, on behalf of Mr. Hunt.
Mr. Hunt, can you please state your full name for the court?
Anthony Lamont Hunt.
All right. Ms. Stevenson, this not working for me. Who spoke to Mr. Smith in the breakout room?
I'll get him back in there with Miss Rockman.
Okay, go back in, let him go back in. All right, with respect to Mr. Hunt, today is the date set for pretrial conference. How are we proceeding? Mr. Moore, how are you proceeding today?
I contacted the prosecutor yesterday, and they said in my office operating while visibly impaired. If that's the case, we'll take that offer.
Okay, so your client wishes to enter into a plea today?
Yes, I advised him of his rights. I advised him of the possible penalties, and he right to waive those rights and plead guilty to operating while visibly impaired.
Ms. Ritter, is that the people's offer?
Judge, that is correct. That's the people's offer at this time.
All right, Mr. Hunt, you would like to accept the people's offer, sir?
Yes, Your Honor.
All right, Mr. Hunt, I am going to share my screen momentarily, and on my screen, you are going to see an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights? Sir, have you
Yes.
had, please have a seat, Mr.
Okay.
Hunt. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, I did.
And when you did that, did you understand your constitutional rights?
Yes, I did.
Sir, do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept the plea from you today, drawing your attention to number 6 on the advice of rights form, do you understand that you will not have a trial of any kind if I accept this plea from you today?
Yes.
Sir, has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to give up your right to a trial and enter into this plea?
No.
Are you currently, Ms. Stevenson? Oh, never mind. Are you currently on probation or parole?
No.
Finally, sir, the court draws your attention to number 11 on the advice of rights form. It indicates that an appeal to the circuit court may be taken within 21 days of the date of your sentencing. However, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to either request permission of this court to set aside your plea or request permission of the circuit court to appeal the conviction.
Yes, I understand.
With that understanding, do you still want to give up your rights to trial and enter into a plea today?
Yes.
All right, sir, raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may put your hand down. Who's going to voir dire Mr. Hunt with respect to the factual basis?
I can't judge if that's okay with the court and defense counsel.
I said, yes, sir, fine with me.
You may.
Thank you. Mr. Hunt, on June 17, 2022, were you operating a motor vehicle on northbound M10 Service Drive and West Grand Boulevard?
Yes, I was.
Is that the city of Detroit?
Yes,
Is that the county of Wayne?
yes,
And while operating a motor vehicle on North M10 Service Drive, well, strike that. Prior to operating a motor vehicle, did you consume any alcohol?
yes.
And did
Not-
the consumption,
Before I was driving, I did consume a beer at the bar. Yes,
okay, and did the consumption of that beer impair your ability to safely operate that motor vehicle?
yes.
Mr. Moore, you cannot answer for your client. Now, first of all, nobody's gonna make me believe that the consumption of a beer impaired his ability to operate a motor vehicle. So we're gonna go back, we're gonna dial it back. Otherwise, I'm not gonna accept this plea. And we're gonna either tell the truth, the whole truth, and nothing but the truth. And if that is the truth, because it's possible that it's the truth, that he drank one beer. Okay, listen to it's possible that it's true that he drank a beer, but it's not possible that that beer impaired his ability to operate a motor vehicle. Now let's go back again. What did he have to drink before he operated the motor vehicle?
I had a beer. I was at the bar watching the game.
All right, I'm
beer.
not going to accept I'm not going to accept the
Ma'am,
plea.
Your
Sir,
Honor.
I need you to let me do my job.
Okay,
I'm not going to accept the plea. I need discovery to be sent over to Mr. Moore. I need to see what his alleged blood alcohol was after he consumed a beer. And then we're going to look into it from that perspective, because I've never in the history of my life known a person to be impaired after consuming a beer. Okay?
Yeah.
okay, ma'am.
Wait,
That's-
Let me
Can I-
tell you this, sir. Don't keep talking to me.
Okay,
yeah, I have had discovery and I reviewed with them that the results were 0.166.
Well, then, if that's the case, then your client is lying on my record. So let's be clear.
okay,
If
Your
that was his blood alcohol level, then your client, under oath, I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. If that is his blood alcohol level, then your client is not telling the truth on my record.
Your Honor. I'm gonna say this, okay.
I don't understand why there's conversation with me and your client
Oh,
while I'm trying to take a plea. That's what I
Okay.
don't understand. Now, the question was asked, what did he have to drink? Your client said he had one beer. So either there's something, the math isn't mathing. Something is not right. And I'm not going to just take a plea for the sake of taking a plea. Either he's guilty or he's not guilty. But if he's not guilty, then I'm not taking a plea. We're not, no.
Sure. Well, that's fine. I talked to you.
So do we want to go back to what did we have to drink? I mean, I don't know.
yes, tell me that.
He said yes. You gotta tell him what you had to drink.
Okay. I had more than one beer, Your Honor.
Ms. Ritter, you can continue.
Thank you, Judge. Mr. Hunt, and did the consumption of those alcoholic beverages impair your ability to safely operate a motor vehicle on that day?
Yes,
And Judge, for purposes of the plea, the people stipulate to the blood alcohol content of 0.16, and with that, the people are satisfied.
I'm also satisfied, Your Honor.
Let me tell you all something. If I'm not serious about anything, I'm serious about two things. One of them, they don't let me discuss in my judicial role. That's my number one thing that I care about, the thing that they tell me that I have to separate. The second thing is I take this job, this courtroom, and this process seriously. Now, what I could do is have Mr. Hunt charged with perjury, but I won't because maybe he was a little confused. But what we know is that he lied today on my record under oath. What we know is, looking at Mr. Hunt, a child could drink a beer and not have a 0.16 blood alcohol. We're not even talking about a 0.06. We're not talking about a 0.08, barely the legal limit. You sitting up here telling me it's a 1 in front of his number, and he got on my record under oath and said all I had to drink was a beer. That's insulting to the court. Your credibility is shot. And it's clear to me that at somewhere in your life, you living in a denial. You living in a denial somewhere. Now, I don't know if you drank a beer and the glass was as tall as you. But if you're going to tell me you blew up, what was the blood alcohol?
0.16.
You blew a 0.16 after you drank a beer. You shouldn't drink nothing else in your entire life, because clearly your body processes the alcohol different than everybody else's body that's alive.
Understood, yeah. I didn't do a good enough job prepping him.
You don't have to prep somebody to tell the truth. You don't have to prep somebody to tell the truth, the whole truth, and nothing but the truth. You don't have to prep them. You don't
I
have
should have
to
been more emphatic, man.
You should have, but he should not have lied.
I
Don't
feel
come
like
on
he
here
did.
lying. Don't come on my court lying. Don't come on here lying. All right, court is satisfied with the factual basis as well, and I will accept a guilty plea to 1 count of operating while visibly impaired.
Thank you.
You're welcome. The court is going to set the matter for sentencing. Mr. Flanagan, November 15th. How do I look?
Just 4 matters.
Court is going to set the matter for sentencing November the 15th. Put it on my docket, Mr. Flanagan, for 9:02. Prior to the sentencing, Mr. Hunt must submit to a pre-sentence investigation and a substance abuse evaluation through the probation department. Probation is going to contact you by telephone. If they cannot reach you, they're going to leave you a message and mail you a letter directing you to contact them. You must submit to the pre-sentence investigation prior to your sentencing so that I can have a proper pre-sentence investigation on the day of your sentencing. Bond will continue with no drinking and no driving without a valid license. Anything further?
No,
No,
thank you.
no, Your Honor.
All right, we're all set. Have a great day and stay safe.
Thank you again very kindly, Your Honor.
You're welcome. I'm gonna go ahead and